With me today for this week's edition of Law Bites is John Spender from Kennedy Partners Lawyers. John is a leading family lawyer and he is presenting a webinar on the subject of later in life relationships on the 4th of April. And John really thinks that the most important case, I think, is the High Court case of Fairbairn and Radecki. Now, the interesting thing about this case, it was a question of whether the de facto relationship was still on foot, and in particular, whether the fact that the parties lived in two separate residences was determinative of that fact. John, welcome. Thanks for joining us. Can you elaborate a bit on this issue? What did the High Court decide and why?
I'm happy to be here, Rob. Just to go briefly explain a little more about the facts before I answer that. The parties had been a heterosexual couple, were in a de facto relationship, an older couple. They had separate residence. They had separate properties. They lived in the wife's residence. I'll call her that for convenience. They had not done a proper financial agreement, but they had done agreements to say that they wanted their properties to be kept separately. The wife suffered dementia. She had to go into care. The husband was resistant to that, resistant to giving her much financial support, resistant to moving out of the house and letting it being sold to pay for the bond. So she was ultimately represented by the New South Wales trustee, and they commenced on her behalf property division proceedings in what was then known as the Federal Circuit Court of Australia. But that was challenged by the husband on the basis that we have not separated. The law under the Family Law Act is that property division orders cannot be made for de facto couples unless they have separated. Now, the full court had held in favour of the husband, but via a case guardian, the New South Wales trustee, there was an appeal to the High Court. Now, at that point, the New South Wales trustee raised a fascinating argument, which was, does the mere fact that they're in separate residences on the proper construction of the Family Law Act mean that they have separated? Now, the High Court rejected that primary argument, looking closely at 4AA of the Family Law Act and saying the nature and extent of common residence is only one factor to be considered among many in determining whether there's a de facto relationship on foot. Also considered that 4AA3 specifically says that no one factor is held to be determinative, and the words nature and extent imply that there could be anything less than full cohabitation with each other. Commenting further that it would be productive of injustice if relationship would be deemed to have ended by mere fact that for reasons of health, as in the wife's case, the parties are living separately. So that argument didn't get up, but in the circumstances where the husband was acting against the wife's interests, refusing to let the house be sold, clearly thinking of his own financial needs, despite the agreement they had reached, thought he wasn't supportive of her situation, it should be considered as a result that the relationship had broken down, even though neither of them had said to each other at any point, the relationship is over. That's, I find, also an interesting conclusion, because there are plenty of unhappy relationships where the parties are not always very supportive of each other, but they go on grimly anyway without ending it, but without being found to have separated. But the High Court, being the High Court, has decided that in those circumstances it was separation. Therefore, the courts exercising jurisdiction under the Family Law Act did have jurisdiction to make property orders. A related issue that the High Court mentioned was whether someone in the wife's position, being demented and represented by a trustee, could make a decision to end the relationship. I wondered that, and in my paper I discuss the fact that possibly under Victorian guardianship legislation, it would be possible for someone who is a guardian, such as an equivalent person to the trustee, to make a decision about personal matters of the protected person, including whether they should live with another person. So theoretically, yes, although I don't know of a case on the point, such a decision could be made by a trustee on a protected person's behalf. Those and other issues I plan to cover next week.
John, thank you very much. That's really fascinating. And for those of you who would like to learn more about this subject, please go to our website. And if you're listening prior to the 4th of April, you can register for the webinar live. Or if you'd like to purchase a recording later on, you can do that as well. John, once again, thank you very much for joining us.
My pleasure, Rob.
And we'll look forward to hearing more next week. Thank you.
Pleasure.